mentioned in the previous episode, divorces for NRIs have a different and more nuanced proceeding due to the varying location of the parties seeking divorce. In this video, we will discuss divorces based on geographical location and how to proceed with it. Further, I will give some of the cases which our firm dealt with to provide you with a better understanding for every scenario. But before that, let us understand what is divorce. Divorce is a legal dissolution of the marital union between two entities. In most of the cases, the separation is granted by the court of law after receiving a petition from either wife or husband. Divorce is usually followed by granting alimony, child custody, child visitation, distribution of property, and distribution of debts. In this series, we will narrow down our understanding of divorce as described in the Hindu Marriage Act 1955. According to Section 2 of the Hindu Marriage Act, the provision of the Act are applicable to anyone who is Hindu, Jain, Sikh, Buddhist by religion, by conversion, or by birth. Further, we will put a deep focus in understanding how divorce proceeds for NRIs and whether they have any remedies available for the scenarios which would be discussed in the later part of the video. Grounds for divorce vary for different personal law. Some of the common grounds for divorce are desertion, cruelty, insanity, bigamy, and adultery. In our first case scenario, we will talk about a case where both the parties are NRIs but want divorce in India. Let's understand this scenario through a case which our firm dealt with. The Garewal family got married in Canada, consummated their marriage in Canada, and had a son out of their wedlock. They never resided in India as well. Due to growing differences in their marriage and demand of dowry by Mr. Garewal, after years, they seek a divorce now. As the marriage took place in Canada and even the son out of their wedlock was born in Canada itself, the Indian courts would not possess any jurisdiction in this case over proceeding towards the divorce. In case of alimony and separation of property possessed by the Garewal family in India, the Indian court can execute only the part relating to Indian property and its separation. While in every other instance, including Mrs. Garewal, complaint against dowry, Indian courts cannot exceed their jurisdiction in the following matter. Assuming that one of the parties to the marriage, in this case Mrs. Garewal, is unhappy with the relationship and seeks an ex parte divorce, which means a divorce filed, proceeded against and granted by the court without the involvement of the other spouse. While this may be legal in Canada if uncontested by the spouse, the Indian courts will usually not recognize such a divorce and the parties will again have to move proceedings on a mutual consent basis only. This is so because the court has hardly any knowledge of whether the summons were properly served and other formalities of an ex parte case were fulfilled. The second case scenario deals with one party being an NRI while the other party being resident of India. In this case, Dev married Niharika in India and lived in India after 5-6 days of marriage. Later, both of the parties moved abroad, but due to growing differences, the parties now seek divorce. Now, in the above case, two different paths are possible. If there is mutual consent between the parties, they can seek a divorce in the new country of residence itself. While if there is no consent, the proceedings can take place in an Indian court as the marriage took place in India. The Indian courts would have complete jurisdiction regarding the said case. The third and the last case scenario deals with both the parties being Indian and moving abroad. In this case, talking about one of the case which our firm dealt with, Namita and Gaurav were in love and got married and moved abroad. The next day itself, with moving to a different country after months of their marriage, differences started increasing. In this scenario, the remedy available shall be same as the second scenario. That is, if the mutual consent is present, the divorce can take place in the foreign state only. While if there is no mutual consent available, one of the party would have to file for a divorce in India only, as the marriage took place in India.
Now we will discuss a vital right associated with divorce, alimony. What exactly is alimony? Alimony or maintenance is one of the most important rights associated with divorce and matrimonial laws. Derived from a Latin term meaning sustenance, alimony refers to a legal responsibility of a spouse to give financial support to the other in case of divorce. Under Section 24 of the Hindu Marriage Act, both the husband and the wife can get maintenance. Further, alimony can be classified into two major types. First, lump sum alimony, where the court directs one spouse to make a one-time payment of alimony to the other. Therefore, the alimony gets paid in a single go instead of recurring payments. And second, recurring alimony, where the maintenance amount is given in recurring payments instead of providing it in a single go. It should be noted that from a taxation perspective, the lump sum alimony is treated as capital receipts and not taxed, and at the same time, recurring alimony payments are considered revenue receipts and taxed accordingly. Now let's understand how alimony is decided when the divorce happens in three distinct scenarios, as discussed before by my colleague Trisha. First, when the couple is married and lives outside India. In this case, one of the spouses might possess properties or financial assets in India, but as discussed before, courts in India will not have jurisdiction over both the divorce as well as the financial settlement. That is, alimony cannot be claimed in India. However, it should be noted that financial settlement done by courts of appropriate jurisdiction can be executed by Indian courts. Second, when one of the spouses is Indian and the couple gets married in India. In this case, the couple will have two options for separation. First, if they have agreed to a divorce by mutual consent and have agreed upon who will pay alimony to whom, then in that case they can file for a divorce and claim alimony in courts of country they moved into after getting married, as well as Indian courts. And second, when one of the parties contests the divorce, in this case either party can file for a divorce, but it has to be in India. In this case, the court will grant alimony based on the following factors. First, the duration of the marriage. For example, if the couple is married for a very long time, the entitled person may receive lifetime alimony payments. Second, the earnings and economic conditions of the individual to provide the alimony. Third, health of both the spouses. Fourth, the spouse that takes child custody would be entitled to receive a greater amount while the child is still a minor. Fifth, the expenditure that can be incurred upon the child's upbringing and education. Sixth, the way of living the wife was used to before the divorce. And seventh, the wife's income and earnings. In the third scenario, where both the spouses are Indians and get married in India and go abroad, again, the spouses will have two options available to them. If there is mutual consent both on divorce and financial settlement, then the courts in India as well as outside courts can execute the settlement. However, if there is no mutual consent, then similar to scenario 2, either party will have to file for divorce in India. Again, the courts will grant alimony based on factors discussed before.
Custody of a child means the right given to a parent by the court to look after the child, especially in the case if the child is below 18 years of age. It is one of the most important issues that arise after the completion of judicial separation or divorce, and the court must decide on this issue. When a parent is vested with custodial rights, then he or she must look after all the basic maintenance of the child, which includes physical, mental, and emotional development of a child, along with ensuring the financial security of a child. The other parent is only given the right to access and visit the child. The ultimate rule for deciding custody is the best interest and welfare of the child. There are four basic parameters for this, and they are: first, proper ethical upbringing of the child in question; second, assurance of the safety of the child; third, imparting quality education; fourth, the guardian in whom the custodian rights are vested must be financially well to do. If the parents are unwilling or unable to take care of the child properly, then the court awards custody of such a child to the close relative. The legislation in India that determines the custody is Guardian and Wards Act of 1890 along with other personal laws. There are many forms of custody, in which the first is physical custody, where a parent is awarded physical custody of the child. Second is joint custody. In this custody, the rights are vested in both the parents, allowing them to keep the child in terms. Third is third party custody. In this, custody is given to neither of the parents but a close relative of the parents because the court deem that the parents are not responsible enough to take care of the child. Fourth is sole custody. The entire rights are given to either of the parent and the other parent is completely kept away from the child. Note, the important thing here is that various statutes relating to various personal laws are applied in case of custody. Also, another important point to remember is that if the child is born outside India, then Indian courts don't have any jurisdiction in this matter.
Stay tuned for our upcoming episode on NRI divorces, where we will try to answer your queries. For any further queries, you can contact us at query@legalhelpnri.com.